Mr. Jones, I'm going to tell you one. Mr. Jones, I'm going to tell you.
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following.
When Mr. Jones interrupts the judge mid-sentence, it's game over. The judge snaps. If you talk over me, it will end very badly for you. That's not just a warning, that's courtroom reality. Sovereign citizens often believe that by refusing to recognize authority, they somehow gain power. But all it does is make the judge more determined to shut them down. The courtroom is not a debate stage. It's a hierarchy, and the judge is the top of that chain.
Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
This is the classic move. Sovereign citizens often try to twist legal language. They throw around phrases like common law, God's jurisdiction, or I do not consent. The goal? To confuse the system into backing off. But here's the catch. None of it actually works. These theories have no legal standing, and judges have heard them all 100 times. When Mr. Jones starts citing divine authority, the judge's body language says it all, unimpressed, unmoved, and unamused.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you won't.
It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and you never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry. Cool. It's not cool. You're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes.
Then it happens, the turning point. Mr. Jones declares that this court is run by God's law. At that moment, the sovereign rhetoric reaches full volume. This is the peak of the ideology rejecting all human authority in favor of divine sovereignty. The irony? He's invoking the laws of heaven while standing in a courtroom built on the laws of man. And the judge doesn't even flinch. He leans forward, eyes sharp, and simply reminds him, "You're still in my court."
That request, we are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I
Ms. Martin does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now.
Tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent. With you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. I ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District and
At this point, the defendant realizes he's not winning this battle, but he can't stop himself. The ideology demands defiance. He keeps talking over the judge, insisting he doesn't recognize the court. And that's where reality bites back. When belief meets consequence, belief loses. The courtroom doesn't bend to ideology, ideology bends to law. And the more he resists, the deeper the hole he digs.
I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
I
Are you aware of any?
question.
Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why.
One of the reasons these courtroom videos go viral is because of this, the tone. The judge never lets chaos take over. While the defendant spirals, he stays cool, steady voice, grounded authority. He's the embodiment of control in a room built on conflict. And that calmness is what ultimately destroys the sovereign citizen argument. You can't argue with someone who won't argue back, only enforce the law.
Know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
By the end, the judge doesn't even need to say much. The courtroom's hierarchy has already spoken for him. The man tried to invoke divine justice, but divine justice doesn't overrule a judge's gavel. This is the crash of two worlds, faith and law. And today, law wins. For sovereign citizens, this is the moment of truth. Reality isn't optional, it's enforced.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
You try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay? But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom? Think about it.
By this point, you can almost feel the isolation setting in. Mr. Jones isn't really arguing with the judge anymore, he's arguing with a belief system that only exists in his head. This is what's called the echo chamber effect. When someone surrounds themselves only with voices that agree, the truth starts to sound like the enemy. The judge doesn't need to shout. The silence between his sentences says everything.
I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your security of this.
How I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
The officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right,
outside.
let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself obviously is a logistics issue since you are incarcerated. The shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there.
This moment hits hard. Mr. Jones genuinely believes he's serving a higher calling. But the courtroom doesn't punish faith, it punishes behavior. You can believe whatever you want outside these walls, but once you walk through those doors, belief doesn't exempt you from law. That's what makes this clash so emotional. One man's conviction versus an entire legal system designed to protect order.
Now, I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now, you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
You have to give the judge credit, this is a masterclass in composure. Many judges would have ended the hearing minutes ago, but he lets Mr. Jones speak just long enough to show the audience why these arguments never hold up. That's the quiet genius of courtroom control, not reacting, but allowing the facts to expose the flaw. The judge doesn't win by force, he wins by patience.
Yourself.
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience? Your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right.
Debatable, though.
Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Mr. Jones? Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later, it's easier to go that way than to go the other way.
Finally, the walls close in. The judge begins outlining the legal consequences, and suddenly, the God's law defense doesn't sound so powerful anymore. You can see it in the defendant's face, the shift from confidence to confusion. This is the crash landing of ideology into reality. It's not dramatic, it's quiet, and that's what makes it hit harder.
You can't have it both ways. What's that?
Can I use the bathroom, please? I really gotta go, sir. I just need to use the bathroom. I'll be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Miss Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Mrs. Martin
No,
to...
I don't want her near me, around me.
This entire encounter is a reminder of something simple. The law doesn't bend to belief, but it also doesn't mock it. It just stands firm. The judge never loses control, never raises his voice, and that calm, grounded authority is what destroys the illusion of sovereign power. If you made it this far, you clearly love Courtroom Breakdowns, so hit subscribe, tap that like, and drop your thoughts below. Do you think these sovereign citizen arguments are brave or just delusional? Because in this courtroom, truth isn't debated, it's enforced.